Namaskaram everyone, my name is Kajal and in today's video we are going to understand how a trial in court of session held. From starting of offense till the execution of sentence, we're gonna cover every aspect in this video, so stay connected. Let's start. So first of all, what happened? An offense is committed. After offense is committed, it come into investigation of the offense. Then police submit the police report under section 193 of Bharatiya Nagrik Suraksha Samhita in the court of magistrate. When magistrate has a police report with him and he see that this case is exclusively triable by court of session, then this case is committed to court of session under section 232 of BNSS. Am I clear? Committal means that lower court transfer whole case to the upper court and now court of session is authorized to decide upon that case. When court of session with him all the details, after committal court of session do what? Court of session has next power to ascertain the inquiry upon the charges. Means that in the police report itself some charges are given that why we have convicted the accused and this is the reasons. Now, public prosecutor open the case. Open the case means what? Public prosecutor come in front of court and he says that, my lord, this is the case. These are the evidences on the basis of we are imposing the allegations of an accused, and these are the suitable reason for it. After that, accused side also give their contentions, and when both parties give their contention, it is upon the court to decide whether there is a substance in the case or not. If court of session consider that there is some substance in the case, means that we should proceed in the matter, then court frame the charges. And if court considers that there are no such substance and no such basis, sufficient grounds on basis of which we should proceed in the case, the court will discharge the accused. Discharge and acquittal both are different, and I will tell you in the last. Clear? So here court has two options. If sufficient ground, then framing of charges. If there are no sufficient ground, then discharge. After discharge, trial ends here. But if framing of charges, then from this stage trial starts. Before framing of charges, there is a process, there is inquiry stage, and when charges are framed, further this is trial stage. Am I clear? So there are three stage in a criminal trial. First is investigation till the submission of police report. Second is inquiry, that whether there are sufficient charges upon the case or not. And the third one is trial after framing of charges. So when court frames the charges, there is particular hearing upon charges. Means that both parties put their contentions that, my lord, these charges are not sufficient. Meaning thereby prosecution wants to put more severe charges on the accused so that he may be punished, but the defense lawyer wants to minimize. That's why he gonna uh, do the attempts to minimize the charges, so that his client may be saved. Am I clear? So here, after framing of charges, court give accused plea of guilt. Plea of guilt means that accused has the option to accept his guilt that he has committed an offense or not. If accused accept that he has committed offense, then court may convict him or court may not convict him. It is upon the discretion of court. And second, if the accused say that no, I have not committed this offense, then in such case further trial starts. Clear? After framing of charges, plea of guilt, and after plea of guilt, further trial means court will fix a date for the prosecution evidence. Now, prosecution side will present their evidences, and in these evidences there are list of witnesses, further evidences or any list of documents or thing that needs to be produced. For witness production, court may issue warrants and summons. Court may issue summons, and when summons are issued, the person has to appear in court. Okay, so when person appear in court, he is chief examined, then cross examined, and then re-examined. Chief examined means the side of the party which have both witness will ask question from it. It is called as chief examination. And when the other party will ask question from the same witness, this is known as cross examination. And when such contentions are raised that the witness is made hostile, then the prosecution side demands for re-examination. This is called as re-examination. Clear? So I hope I am clear upon what is chief examination, cross examination, and re-examination. Then all witnesses are examined number wise, and when all this list is completed, a lot of evidence is produced in front of court. The court will proceed further. Next stage is examination of accused under section 351 of PNSS. Meaning thereby, court will ask questions from him that these are the prosecution evidences. Do you want to say on this something that you have committed the offense? Do you want to accept your guilt? At this stage also, the court may acquit him or convict him. If the person say that yes, I have do committed, then court will convict him, or otherwise court will continue the trial. Clear? So now, after examination of accused, if accused does not accept his guilt and want to seize further, then court will fix further date for defense witnesses. And now defense will come in front and produce their own side of evidences on witnesses. And in the same way, these are also chief examined, cross examined, and re-examined. After all these things happens, a date will be fixed for the date of final arguments, in which prosecution side and defense sides both appears and put their contentions and sum up what they want. These are like final closing statements upon their side. Okay, so this is final argument. After final arguments, then comes the date of judgment, in which court has the discretion upon all the merits of the case after considering the police reports, list of evidences, witnesses, everything which is produced in front of him. He gonna decide upon this that the person is guilty or not. If the person is guilty, he gonna convict him, and if the person is not guilty, he gonna acquit him. Plus, acquittal means trial ends. But if the person is convicted, and it is to be seen that then next day for the date will be fixed for quantum of sentence. Meaning thereby, both parties will contend their own part that the how much punishment is to be given to that person. Both party argues, and then court decide that this much punishment is to be given to that person. If it is sentence, then it is executed in different way, and if it is a death penalty, then the case is sent to high court for confirmation. Then high court will confirm the death penalty, and then court of session has the power to execute the death penalty. Then the person is executed in the way he is punished. So this is the process of whole trial of court of session. This is the lengthiest trial in our criminal justice, you can say. From starting of offense investigation submission of police report, framing of charges, then we have prosecution side, prosecution's witness, examination of accused, defense witnesses, and after defense witnesses, we have final arguments, then date of judgment, and then quantum of sentence, final. Then we have what? Final conviction. So this is how whole the trial begins in a very lengthy process. We have completed this trial in 10 minutes. But if you see in practical sense, many years, 4 to 5 years goes on this trial, because you know about English Indian justice system. Anyway, if you do like my video, then go through all the provisions provided in our Sanhita, this Sanhita. Okay, you have to go through from this, and if any doubts, leave in the comment box. I'll be ready to give you answers. Thank you.